All right, court does call the case of the People versus Javon Williams.
This opening moment may feel casual, but it immediately signals the shift into a far more serious proceeding. Judge Simpson clears the previous docket, and the courtroom energy changes instantly. What you're witnessing here is the quiet before a storm, because competency hearings are not routine formalities. They decide whether a defendant can even stand trial, and that determination shapes the entire future of any criminal case. Before the name Javon Williams is even called, the tension is already building. The prosecutors, defense, and court staff all know this hearing has major consequences. If Williams is found incompetent, everything pauses. If competent, the legal machinery moves forward toward trial. This early court chatter also matters because it contrasts sharply with the intense forensic testimony that's about to unfold. Judge Simpson's tone is steady, but beneath that calm is an expectation of clarity, evidence, and expert reasoning. Competency is not about guilt or innocence. It's about cognitive ability, rational understanding, and mental stability, all of which will soon be dissected under a microscope. As we head into this hearing, ask yourself, if someone can repeat legal definitions but cannot apply them rationally, should they be considered competent? That's the core conflict you're about to see play out, and both sides believe the stakes couldn't be higher.
Your Honor, thank you, and good afternoon, Jonathan Evans on behalf of the people.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Javon Williams. Mr. Williams, would you please state your name for the record?
Javon Williams.
All right, very good. All right, this is a date and time set for a competency hearing. I believe it's been set at the request of the people. All right. All right. The court has reviewed the report that was filed.
Excellent.
And that is the December 12th report. Ms. Gaines, you have a copy of that also, is that correct?
Yes, Your Honor.
All right. And it's really, I guess, the people that are challenging that report or
That's
questioning that report. All right, very good. All right, you may proceed.
Thank you, Your Honor. At this point in time, I guess unless there's an objection to it, I'll just call the witness and do the direct, if that's okay.
No objection, Your Honor.
All right, very good. You may
Call
call.
Dr. Huda.
All right. Doctor, if you could please come forth to be sworn. All right, you may inquire.
So we have your name, your current employment,
I am a psychiatrist at the Center for Forensic Psychiatry.
and how long have you been so employed?
I've been in this position for about a year now.
Okay, and have you ever previously testified in cases regarding competency or criminal responsibility?
This section highlights the expert's qualifications, an essential foundation before her opinions are accepted. The prosecution wants the judge to see a seasoned professional whose evaluations aren't guesswork but built on training, repetition, and standardized methodology. Over 100 competency evaluations is not a small number. It suggests experience with a wide range of defendants, mental conditions, and situational complexities. The fact that she has been certified as an expert in previous cases strengthens the credibility of her findings here. Courts often rely heavily on such credentials because competency evaluations require nuanced distinctions. Is a belief irrational or is it delusional? Is the defendant misinformed or unable to understand? These lines blur easily without clinical expertise. For viewers, this is the courtroom equivalent of sharpening the scalpel before the operation. The judge needs confidence that the person interpreting Williams' mental condition is equipped to do so. Without this foundation, the entire hearing could collapse under objections. Ask yourself, does expertise automatically equal accuracy, or should courts look for corroboration from multiple experts before reaching such a critical decision?
I testified in one conference.
Okay. And do you recall whether you were certified as an expert in the field of forensic competency or forensic criminal responsibility in that case?
I believe I was certified as an expert in forensic psychiatry.
I'm sorry, forensic psychiatry. It's been a long day for me. And how many times have you completed forensic exams for these types of hearings?
I've conducted about 170 competency evaluations.
Okay. And at this point in time, Your Honor, unless there's any objection required here on the issue, I just move to admit her testimony on the basis of that of an expert.
No objection.
All right, she's so qualified. Go ahead.
In that capacity, working for the Forensic Center, did you have an opportunity to evaluate the defendant, Mr. Javon Williams?
Here we enter the heart of the factual evaluation. The expert confirms she interviewed Williams and reviewed relevant materials, court orders, background information, and other documents that help form a mental status picture. Competency evaluations must be grounded in both interview observations and collateral data, because defendants can exaggerate, minimize, or misrepresent information. Notice how carefully the attorney asks about the materials reviewed. This is not small talk. It's a strategic setup. If the expert reviewed too little, her findings may appear shallow. If she reviewed enough, the defense has a higher burden to challenge her conclusions. What's especially important is the expert's indication that the video interview did not impede her ability to conduct the evaluation. This shuts down an avenue of attack that attorneys sometimes use. Arguing the setting influenced the defendant's presentation. This moment is building toward a key question. Did Williams understand the proceedings, and could he assist in his defense? Understanding these early foundational answers is crucial to interpreting the expert's later, more dramatic conclusions about delusion, paranoia, and irrational decision-making.
Yes, I met with Mr. Williams on 2 occasions.
Okay, and did you get any materials ahead of time to review prior to your interview with him?
Yes, I received the court orders and the police report.
Okay, and you said you met with him twice. Can you tell us what medium interviews were done over?
They were by Zoom.
Okay. Did the video impact the video interview? Did that have any impact on your ability to conduct the interview?
I don't think that it affected the ability.
Okay. And so, in your capacity of forensic psychiatry, you're obviously familiar with Michigan's competency statute.
The attorney strategically walks the expert through the legal definition of competency, not to educate her, but to anchor her testimony within the statute. Michigan's test is straightforward. Defendants are presumed competent unless mental illness renders them unable to understand the proceedings or assist in their defense rationally. This matters because even if someone understands legal terms or court roles, they may still be incompetent if their reasoning is impaired by delusional thinking. The distinction between knowledge and rational application is critical, and this is where the expert's evaluation of Williams will soon become controversial. The attorney is setting up a tension. Was Williams merely misinformed and stubborn, or was his entire legal strategy shaped by psychiatric symptoms? Jurors in regular trials don't hear this kind of reasoning, but competency hearings hinge on these subtle cognitive distinctions. Viewers should pay attention to how confidently the expert answers statutory questions. These aren't trick questions. They establish that her conclusions rest on the legal definition, not an improvised clinical judgment.
Yes.
Okay, and so fair for me to say that the presumption is that somebody is competent. That's the first part. And then if I get this right, unless because of his or her mental condition is incapable of understanding the nature and object of proceedings or assist in his defense in a rational manner.
That's my
Okay. And then the caveat, assist in his defense in a rational manner, that means it is defined as the ability to perform the tasks reasonably necessary for him to perform in the preparation of his defense during his trial.
I'm not sure off the top of my head.
Oh, okay. All right. So I want to first move into this area of understanding the nature and object of the proceedings. In your interview, you got some background information from Mr. Williams, correct?
Yes.
And he indicated to you that he was a graduate from Pioneer High School. He said that he was an AP student honor roll. He gave you some information about his college education. Do you recall that?
He said he's completed some college.
Okay. I think he said like a sophomore year at Eastern and then some community college.
I believe that's what he told me.
And this is just kind of getting to it. Do you have any thoughts about the truth of those statements, whether they're true or untrue?
I don't have information to suggest otherwise.
Okay. So in the face of anything else, his self-reporting of that, you have to just take it at its face.
I didn't question what he told me about his education background.
Right. Did you inquire if he had any medical conditions that could affect his ability to participate in the interview?
Yes. Is it okay if I refer to me?
Here the testimony shifts to Williams' medical and mental health history. What does one of the most influential components of any competency determination? The expert notes past injuries but no reported conditions that would interfere with cognition. More importantly, she references his psychiatric history, including hospitalization and disagreements with prior diagnoses. This is a critical clue for viewers. Many defendants minimize or deny mental illness, not out of deception, but because symptoms distort their insight. The expert's calm acknowledgement of his disagreement with diagnoses hints at possible paranoia or defensiveness. This timestamp also reveals an important dynamic. The attorney is building a record to evaluate whether Williams' reported symptoms align with his current presentation. Competency isn't about one moment, it's about patterns. Did past hospitalizations relate to delusions? Did he show signs of impaired reality testing during the interview? Was his reasoning distorted or inflexible? These answers foreshadow the expert's later conclusion, that Williams exhibits delusional thinking affecting his legal strategy. Before that evidence emerges, viewers should consider, does denying past diagnoses mean someone is clear-headed, or can it itself be a symptom of impaired insight?
Yeah, you obviously prepared a report in this matter, correct? And you had an opportunity to review that. And would you think that reviewing that report today would refresh your recollection for that question?
Yes.
Then I don't have any objection to you reviewing the report. If I've got a copy of it, if you need a copy, but if you have your own, you're more than welcome to look at it. Excellent. Just let me know somehow that you're done reviewing it and your memory's been refreshed.
Mr. Williams reported a history of sports-related injuries. He really denied any other significant history.
Okay. What about his mental health history?
He reported a history of having been psychiatrically hospitalized in the past, although he disagreed with the diagnoses that he received while hospitalized.
Okay. In your interview with him, was there anything that suggested that he was currently, at the time, suffering from any visual or auditory hallucinations?
No, he did not appear to be.
In terms of his functioning at that point in time, anything that was of concern while he was in the jail, the way that he appeared, the way that he spoke?
He functioning in terms of caring for himself, general stability. He seemed to be generally functioning.
Okay. No noticeable tics or anything that seemed to be or uncontrolled fidgets.
No abnormal movements.
Okay. And how would you describe his demeanor during your two interviews with him?
During the initial interview, his affect was rather guarded. He was appeared less guarded during the second interview.
Okay.
His thoughts were well organized and coherent. He was calm and cooperative. He was well spoken. His clinical presentation was most notable for what appeared to be delusional, paranoid, and persecutory beliefs.
This is one of the most important lines in the entire hearing. The expert concludes that Williams' presentation reflects delusional, paranoid, and persecutory beliefs. In forensic psychiatry, those terms carry tremendous weight. They mean his thinking isn't simply stubborn or emotional. It may be detached from reality in ways that directly impair decision-making. Delusions differ from strong opinions. They aren't corrected by evidence. They aren't weakened by contradiction. They persist even when logically impossible. This testimony indicates that Williams' worldview, particularly relating to accusations, threats, and interpretations of other people's intentions, may be distorted in a clinically significant way. What the court must determine is whether these distortions interfere with his ability to consult his attorney rationally. For viewers, this is the turning point where the case shifts from factual conflict to cognitive conflict. The expert is drawing a line between personality-driven defensiveness and psychiatric impairment. And that distinction is where the judge will later struggle. If someone cannot distinguish between real threats and imagined ones, can they meaningfully plan a legal defense?
We'll get to that. Just want to back up a little bit. You use this term, guarded. Can you explain to us what that term means to you?
Guarded meaning not forthcoming and withholding some information.
And you indicated that there was some concern that he was paranoid, having thoughts of persecution. Is that, if you want to explain that a little bit more?
He made some statements that appeared delusional.
Part of that competency standard statute is understanding the nature of the charges. Do you believe that he was able to understand what he was charged with?
Yes.
Okay. He was able to demonstrate to you knowledge of what pleas of guilty versus not guilty were. Do you think that he understood what a plea of no contest meant?
Yes.
What about not guilty by reason of insanity or NGRI?
He initially said that he was unfamiliar with that plea meant, and I gave an explanation, and in talking about it further, he was able to recall and repeat back what I had told him. So he demonstrated an ability, at least a basic ability, to retain and recall relevant legal information.
And you would agree that that's something that is important in participating in a court process, demonstrating recall and kind of using that information.
That is generally relevant.
This section exposes the heart of the competency dilemma. Williams can recall information. He can repeat legal definitions. He can describe courtroom roles. On paper, that sounds like competence. But the expert emphasizes a deeper question. Can he use that information reasonably? Competency requires functional reasoning, not academic memorization. A defendant might know what a plea deal is, yet believe a supernatural force will intervene before sentencing. They might know what a witness does, yet assume every witness is secretly part of a conspiracy. The prosecution uses this section to show he understands the basics. The defense will later argue that understanding alone is insufficient if his decision-making is impaired by delusional thinking. This timestamp reveals the foundational tension that the entire hearing wrestles with. Can someone be knowledgeable yet incompetent? It's a question courts battle with constantly, because mental illness does not erase intelligence. And intelligence does not guarantee rationality.
Did you ask him about the nature of plea bargaining?
Yes.
What about the roles of judges, juries, prosecutors, defense attorneys, and witnesses?
Yes, he demonstrated a generally good understanding of the roles of key courtroom person.
And what about courtroom procedure?
Generally demonstrated a sufficient ability to understand courtroom procedure.
Okay. And based on your interviews, and that he's obviously been in the courtroom just for a little bit here today, but he was able to demonstrate courtroom decorum. Now, I think if I have this right, your conclusion really turns on to this assist in the defense. Is that right? Okay. I think your conclusion was that you were, hold on. I think, at least when you interviewed him for purposes of the report, at that point in time, he had not seen the police report, is that right?
That's what he said.
Okay. But he indicated that was something that he would want to see. Okay. Your conclusion was that, if I get this right, Mr. Williams appeared to, and I'm just quoting, to view evidence or information from the report as favorable, despite that to this examiner, that same information appeared to be unfavorable.
This is a critical pivot in the testimony. The expert explains that Williams repeatedly interpreted clearly unfavorable evidence as if it helped him. This type of distortion isn't mere optimism, it's a hallmark of impaired reasoning. For example, believing a construction worker's testimony would support him even when the police report indicates otherwise suggests a rigid belief system disconnected from reality. In competency evaluations, this rigid misinterpretation is treated as a red flag. The defendant may be unable to weigh evidence logically, anticipate courtroom outcomes, or participate meaningfully in strategy. The attorney appears confused here, signaling that the expert's clinical framing doesn't align with his legal framing. But that confusion underscores the gap between psychiatric interpretation and courtroom logic. The expert is essentially saying he thinks evidence helps him when it clearly hurts him, and he cannot be dissuaded from that belief. This is where viewers must ask, is this denial, deception, or delusion? The expert firmly leans toward delusion, and that distinction shapes the outcome.
Can you explain this?
So, for example, when I initially asked about the witness that was mentioned in the police report, instruction order, Mr. Williams initially appeared to assume that the construction worker's testimony would help his case. He also referenced text messages that he appeared to believe would support his case. But in that particular statement, I was referring to his talking about instruction.
Okay. So the police report obviously details what that quote unquote construction worker says, right? And then he expects, not having read the police report, that the construction worker will testify to something different.
Initially, that was during the initial interview.
Okay. Did that then, I'm led to believe that then changed?
I read portions of the police report to Mr. Williams, and despite presenting various pieces of evidence from the police report, he did not appear to be responding to that information in a rational manner.
All right. And so this is kind of where I'm having a little bit of my trouble, because I don't know. I don't know what you're talking about, Doctor. I don't know that I have enough of an information. I've obviously read the police report. I'm obviously familiar with what I believe the facts of the case are. But I don't know what you're taking from him. So I just need a little bit more insight to kind of let us in a little bit more.
Mr. Williams appeared to be experiencing delusional beliefs about the alleged victim that informed his legal strategy.
Here the expert finally clarifies the core of her conclusion. Williams' beliefs were not just mistaken, they were delusional in nature and directly informed his legal strategy. This is the turning point in the hearing. She emphasizes that he believed the victim would be exposed and that he would automatically be found not guilty, regardless of contradicting witness accounts or evidence. This demonstrates a lack of rational evaluation. The key word is insistent. Not hopeful, not defensive, but insistent in a way that resisted every piece of evidence presented to him. That is the hallmark of reduced insight and impaired judgment. The defense tries to argue that insisting on innocence isn't proof of incompetency, and ordinarily that's true. But insisting that incriminating evidence is actually exculpatory and applying that belief as the foundation of legal strategy is where competency breaks down. At this point, viewers should start to recognize why the prosecution requested this hearing. Williams' reasoning wasn't merely flawed, it appeared structurally disconnected from reality.
Even when presented with evidence that would undermine his strategy, he was adamant that, and I'm hesitating to inappropriately disclose information that he told me.
Right.
But Mr. Williams was insistent that once he talked about how the victim, the alleged victim, was stalking him, harassing him, he would be found not guilty, and that it was not possible that a jury or the judge could, in fact, believe the Ms. Farah or the construction worker or the surveillance. That appeared to be due to his mental condition.
We can agree that someone insisting that they're innocent in the face of overwhelming evidence is not necessarily a basis for incompetency.
In this case, in looking at the overall clinical picture, I think his insistence and his inflexibility and his rigidity of thinking was consistent with his experience in the mental condition.
Okay. But on a general level, right? Somebody's like, I'm gonna be found not guilty, you know, whatever. That alone doesn't say well, that person is clearly incompetent.
Sure.
Okay. And then you indicated that I think we spoke over the phone prior to this hearing. We spoke a little bit today beforehand, correct? And you indicated that during your interview that there are times that when he is self-protective. Is that right?
Yes.
What does that term again mean to you?
When I say self-protective, I mean not disclosing information that could hurt his case. I always tell defendants up front that my report goes to the judge and the prosecutor.
The expert introduces the concept of self-protective behavior, a crucial factor in distinguishing deliberate concealment from psychiatric impairment. All defendants try to protect themselves. It's natural. But the expert suggests Williams's self-protectiveness may stem from both normal and psychotic factors. This is where competency becomes extremely nuanced. A defendant may withhold information for strategic reasons, but if they withhold due to paranoid beliefs or distorted thinking, that withholding may indicate impaired ability to collaborate with counsel. Williams's selective disclosure, combined with delusional beliefs, creates a complicated picture. He may not trust his own attorney, may misinterpret legal advice, and may reject accurate explanations in favor of irrational alternatives. This undermines the foundation of attorney-client collaboration. An attorney cannot develop a defense with a client who misperceives reality, rejects factual corrections, or refuses to acknowledge unfavorable evidence. This segment illustrates why competency findings are rarely simple. It's not about a single symptom, it's about the functional impact of symptoms on legal decision-making. If you were the judge, would you interpret this as intentional manipulation or impaired reasoning?
And so to be self-protective would be to not reveal information that could be incorrect.
Okay. And there are both psychotic and non-psychotic reasons for somebody to be self-protective.
I suppose so, yeah.
Now, so there's this idea out there, I'll come back to that later. So his legal strategy, I think in your conclusion, again, is that his legal strategy is based on delusion. Therefore, he can't assist his attorney because he's asking them to endorse a delusion. I may be expounding that a little bit. Is that, but do I understand that correctly?
And he can't rationally assist his attorney.
Okay. All right. I also played for you. I also, prior to this hearing, gave you, I believe, 3 audio files, correct? 3 different jail calls between Mr. Williams and a relative. You've had an opportunity to review those ahead of time. Thank you. Your Honor, for the court, I'd like to play at least 2 of those jail calls.
This is where the hearing takes a dramatic turn. Jail calls are powerful because they show raw, unfiltered thinking. No attorneys, no courtroom pressure, no structured interview. The prosecution uses them to test whether the expert's findings hold up when compared to Williams' real-world speech and reasoning. What's striking is how drastically his explanations shift across calls. His narrative about the incident becomes more elaborate, more contradictory, and more infused with emotionally charged claims. In one moment, he insists he was handing someone a PPO. In another, he didn't recognize the woman. He fluctuates between admitting actions and denying them. That instability often signals impaired insight. The prosecution's goal here is simple: determine whether these calls reinforce the expert's conclusion or undermine it. If the calls show distorted reasoning, poor reality testing or delusional thinking, the judge will view the expert's assessment as even more credible. For viewers, this moment invites a key question. If a defendant shifts stories based on emotional state rather than facts, is that manipulation or cognitive disorganization?
Any objection? All right, go ahead. Try it again. Okay, I'm getting older. You're gonna have to move it closer. Put it up here so it can be picked up on my mic. All right. Once we get our new system in, we'll be good. All right.
I'm alright. How are you? I'm good. What's going on, babe? I think I'm going to prison. Prison? Mm-hmm. For what? Man, I got into a fight with this girl who's stalking me. I was in an alleyway and she tried to hit me with a car, and the police chased after me. They're trying to charge me with, I don't know, like 2 or 3 years in prison because I was wearing a bulletproof vest, and they're trying to say that I assaulted her, and they're trying to give me like 4 to 5 felonies right now. This bitch just almost, like this girl just almost ruined my life. But I didn't know what to do. I don't got nobody up here. Everybody else is dying and out of the state, so I wanted to call and let you know this might be my last time talking to you. No. So did they give you a lawyer yet? They're trying to give me a public defender, but I was going to try to get my own lawyer. So that they're probably better. Yeah, but that costs a lot of money. I was just about to get some money from school. I was just about to enroll in the second semester, and I was literally handing this woman, handing this girl this PPO notice to inform her that she was on a restraining order and that we have a court hearing tomorrow for it. But she recognized who I was, started screaming that she was going to call the police, tried to hit me with their car. And it's not funny. I'm really not laughing. I'm really upset that I might have just ruined my chances to gain a name for myself somewhere in society. So right now I'm in the jail. I've been here for a day or two. How are you? The public defender says, not public defender, but your lawyer, which is, I guess, one of them, but. So I was supposed to speak to someone today. I think I might have a chance to beat the case. I think I have a good case argument, I can say.
This specific portion of the jail call reveals the internal conflict in Williams' thinking. On one hand, he acknowledges involvement with the mental team, hinting at awareness of psychological concerns. On the other hand, his narrative remains highly dramatized, claims about being chased, nearly killed, misunderstood, and repeatedly victimized. This mixture of insight and distortion is exactly what makes competency assessment so complicated. He knows enough to recognize he is in trouble, knows he may need legal help, and knows mental health is part of the process. But simultaneously, he frames events in a way that places blame entirely outside himself. The expert must determine whether this is self-serving exaggeration or genuine impairment in reality testing. The judge must decide whether such distorted recounting means he cannot participate rationally in his defense. Many defendants minimize culpability, but Williams' shifting explanations and dramatic overemphasis of danger suggests deeper cognitive rigidity. Do you think he understands the situation but refuses to admit fault? Or do you think he truly perceives events through a distorted mental lens?
I'm working with the mental team. I can say that, yeah, I'm under a lot of stress. This girl's been stalking and harassing me. I can say I was wearing a bulletproof vest for safety measures. I've been getting a lot of death threats, whatever. I'm already on probation. I'm in here on a tether. So I don't know what to do. I wanted to just call somebody who I trusted, who I love. I got my phone in here, but I haven't been able to get to my cell phone to see if I have the funds for a lawyer, but I just wanted to call and say hello. I don't know my aunt's number. I don't really have many people up here left, so if all goes well, I won't get sent to prison. But they said, they said wearing the bulletproof vest, the cop was being a real douchebag. He was trying to say wearing the bulletproof minimum 2 years automatically, and they say, oh, you broke her window, that's felonious assault. You had a weapon and this and that and what and the other, so I really don't know what to do.
Who is this? She's from around Ann Arbor?
Yeah, this older girl I used to mess around with. She's super rich. She owns a little restaurant. She's a spoiled brat, and she didn't know when to say no. I tried to get her to leave me alone, but she just kept following me around, stalking, harassing me, claiming that I'm her baby daddy and all this, what and the other. So I kept saying, come on, go get the test. And she's like, no, I don't want to be around you. But then she's following me around, making threats to have somebody kill me and all this crap. And I'm just like, man, I'm in school. I'm trying to play for the sports team. I'm trying to enlist in the military. I'm trying to get my life together. And you know, using drugs and can't even get your stuff together and want me to father your child. I can't do that without you being on the straight and narrow too. And then this happened yesterday. She almost hit me with the car. So, I mean, I may have blown up. I should have ran for it. I know, but I jumped on her car after she tried to hit me with the car, and I took a swing at her. She probably gonna say,
Did somebody use a bulletproof vest?
I mean, I was wearing one because I keep getting these death threats from people. You know, we're gonna shoot
Yes,
you.
I've not said that before. Yeah. But I'm just like wondering, someone gave you that. So,
I bought it a couple years ago, but I think the dude was lying. I looked it up. That's not illegal to have one of those. But yeah,
Yes.
right now,
Why would they sell it? If it's illegal, why would they sell it?
why would they what?
If it's illegal, why would they be selling it?
Right. You don't need to have a CCW for one. You don't need a CDL for one. I hate calling you every time I'm in trouble. It's like so stupid. And I was doing so good. I'm living with Tammy right now. I haven't even called her and told her I'm here. Her daughter works here as one of the nurses we're used to. And I'm just so fed up with all this crap. I really just want to run for it. But running away from your problems don't make them go away.
Nah, that just makes it worse later on. But hopefully just gotta see you through it, and then you just make better decisions.
That's good. I'm praying that I don't get sent to prison. I don't know what my charges are. They tried to fill out a list of them yesterday. I have most of the stuff on camera. So I have her chasing me down the street with a bat, parking on the side of the road, yelling at me, yo, you might recognize this girl. I mean,
I don't know. But that shit's been around in our room. I'm like our neighborhood, probably.
well, I mean, it's not, it wouldn't make a difference of who she was or what she had. But the situation is the same. It's that. And I just got news that my little brother might have been lost or may have got hurt in some BS that my mom was involved in. I don't know, something having to do with a gang. So I keep hearing news that everybody in the family is in a gang of some kind. Barry James, my mom, Yvette, Shalise, Jasmine. And I just don't know what to do. They all in a gang. They all got some type of gun or a fat wad of cash. And I'm still out here living on the street, homeless, struggling, trying to do the right thing. And it's like,
This part of the call sheds light on Williams's self-image and emotional turmoil. He expresses homelessness, instability, family conflict, and pressure to do the right thing, yet frames himself as surrounded by chaos and betrayal. His references to gangs, family members being involved in danger, and receiving death threats illustrate a worldview dominated by threat perception. The expert likely saw this pattern as consistent with persecutory or paranoid thinking. It's not the content alone that matters. People can face real danger. It's the structure of the narrative, diffuse threats everywhere, shifting explanations, and absolute certainty that he is being targeted. This worldview directly affects competency. A defendant who perceives danger everywhere may struggle to judge witness credibility, trust legal counsel, or evaluate evidence objectively. It also highlights why competency is about function, not diagnosis. Regardless of labels, the issue is whether his thinking helps or harms his ability to participate. Is this a man overwhelmed by life circumstances or someone whose reasoning is fundamentally impaired?
I'm getting nowhere. I'm running in circles.
Right. You just can't quantify your life with anybody else's life.
Don't quantify my life there, so I need to go. I'm in here right now solo. So I'm not in here looking to get recruited by no gang. I don't want to work for nobody who's a rich person to go do some killing or do some dumb stuff. I mean, I'm working a day job. I'm going to school. I have a car.
That's good.
I work out, what God bless me just once without something.
Yeah, just, everybody goes through a hard time, and that's basically your opportunity to make sure you just don't make those decisions anymore. Because you don't want to be where Perry and things are.
Perry's out of jail, apparently. So Perry's out of prison, but James is still in prison.
Yeah, so you don't
Right,
want
I don't want to be there. I thank God that I don't have a weapon, because I would have probably tried to hurt that girl. She's older than I am. She's older than me by like a handful of years. I'm not holding that against her, but do women not know when they're being wicked?
to.
I just don't care.
That's true. Sometimes, every girl is different. You get those crazy girls, and then you get the ones that aren't crazy. But just like girls like that, boys tend to go for the crazy girls for, whatever reason. So it depends on the girl, just like it depends on the guy. You kind of look past all those little stupid things that they do to give you red flags. Like, but you like her, like she's cute, or she got a nice body, or, she just did it that one time, but you can't look past those things. If it's something that's not right about her, you gotta go ahead and throw the flag in and say, no, I think we work better as friends kind of stuff. But I'm sure there was something that told you before this incident that, maybe I should step away from her, but it was something about her that you liked, or made something about her that made you feel comfortable with her to want to stay around. So
They say don't get married to your mom's side of the picture.
yeah.
And I've been living by that. Some girls just don't like that. I don't know. I don't want to talk about no girls like I do on the phone, but I am incarcerated right now. I have been here for 1 day. I am not planning to go to prison. I pray to God that they don't sentence me to anything. I hope I don't do any jail time. I know I have a violation of probation. I know me and this girl just got into an altercation. But other than that, I think that I will be clear. They might have caught me on camera slashing someone's tire. And they might have me on camera swinging on this girl. But Lord knows that I was trying everything to keep her away from me in the first place.
Here we see a fascinating cognitive contradiction. Williams acknowledges the possibility of incriminating evidence, camera footage, physical altercations, yet still maintains a narrative of innocence rooted in external blame. This duality is central to the expert's conclusion. On one hand, he can identify harmful evidence. On the other hand, he misinterprets its significance or believes it will somehow help him. That inconsistency suggests impaired reasoning rather than simple denial. Most defendants, when recognizing evidence against them, adjust their expectations or legal strategies. Williams instead oscillates between admitting facts, minimizing them, and reframing them in self-serving ways. This undermines the defense attorney's ability to plan. If counsel cannot rely on the client to maintain consistent, reality-based explanations, preparing for trial becomes nearly impossible. This timestamp also highlights that insight is not all or nothing. People can understand some aspects of their situation while misunderstanding others in ways that still destroy competency. Would you trust a legal strategy built around such inconsistent self-assessment?
That sounds like, I don't know. I hope I don't get sentenced no jail time. I'm really doing good right now. I'm in school, I'm working out, I'm getting bigger and stronger. My mom's not here to push me down. I'm gonna pray for it. I got a little bit of money in my wallet, so I might be able to buy some phone time to call you.
Okay.
I'm sure you probably know the process. I can give you my number and stuff. I don't know what my mom does too. But I got a little bit of money coming right now from school, so hopefully if this all goes well, I won't be in here for, I've never been in jail for more than 90 days. So.
I'm sorry, I'm gonna skip ahead. He's gonna give his badge number in the jail. I'm gonna protect that information. It's not
All right,
redacted.
that's fine.
Of course,
Or
right?
maybe not, right?
And to apologize to her, she might drop
All right, I'm gonna pick it up from here.
the charges. I broke her window. I mean, she almost hit me with a car. She almost ran me over with the Cadillac Escalade. And so I jumped out of the way. It was wrong. I could have ran for her. I don't know how to.
What you had? If you
What, it
had
was me?
Yeah.
Oh,
If it was,
yeah, I already know.
yeah. If you had a pending PPO or something, it's probably best that you don't even try to contact her or whatever.
But the PPO is her against me, so she can't come into contact with me. I put a PPO on her because she's been stalking me. So when she saw me in the alleyway, I knocked on her window of this vehicle. I didn't know who she was. And then all of a sudden, I'm standing there wondering, like, is this you, homegirl? I hope so. I was like, I wonder. And then all of a sudden, the car backs up, and she comes right back down the alleyway. I don't give a damn. Get out of my life. Like, you think you're smooth? And it was just sounding upset. And that's when I tried to leave. But then she was like, I'll run you over, mother effer this. And she tried. And at that point, I jumped in her. I shouldn't have done it, but I swung at her. And I could have ran, but then I broke her window, and then I started running. So, I don't know. I feel bad. Never raise your hand to a woman.
This portion of the call reveals a rare moment of clarity. Williams admits wrongdoing directly. But even here, the clarity collapses when placed in the larger narrative. Instead of standing as a factual acknowledgement, the admission is tangled in justification, emotional framing, and shifting interpretations of who initiated contact and why. For competency purposes, this matters because it demonstrates selective insight. He can admit harmful details, but he cannot consistently interpret their legal meaning. A defendant who acknowledges breaking a window yet simultaneously insists he was entirely justified may reject plea deals, overestimate his chances at trial, or misdirect his attorney. The expert's job is not to determine guilt. It is to determine whether the defendant can meaningfully engage with that question. And Williams' fragmented mix of acknowledgement and distortion raises serious doubts about that ability. If someone admits wrongdoing but interprets it as unavoidable or irrelevant, can they truly assist counsel in evaluating defenses or negotiating outcomes?
Right. Well, just keep your hand up. And when you got a call, give me a call.
I'm sorry.
You want to call? Not a problem.
This is not my lifestyle.
No.
I feel like a caged animal. I'm not going to make
Thank you for using Securus. Goodbye.
Thank you. Doctor, I talked to you about your findings, and I was putting my card on the table here.
Your Honor, if I could just make this one thing, please. I'm sorry to interrupt you, Mr. Evans. I wanted to make it clear that I was only not objecting for the purposes of the competency hearing.
Two of these.
To this particular.
Exhibit.
Definition of the exhibit.
Okay, very good. All right, that's fine.
Yep, that's all, the only purpose that I wanted to, for this hearing. Thank you. Doctor, putting my cards on the table here, I don't disagree with your conclusion that, in essence, the things that he's saying are probably not true. But I come to a different reasoning why. Where you, I believe, say that his beliefs are grounded in delusions, I believe that he's.
Objection, Your Honor.
Well,
And
I think well, it's argumentative, certainly, as to the conclusions, because what you're posing to the doctor is what may be your feelings. I mean, is there something that you're basing?
I can rephrase it.
Please do.
I believe you've had an opportunity to listen to this phone call, right? Wherein he described that he got into a fight with the girl who was stalking him. He was trying to hand her a PPO. She recognized me. She was going to call the police. And then she tried to hit me with the car, correct?
I don't have a word-for-word transcript, but that sounds like what I'm saying.
Okay. At that point in time, you heard the phone call. He defined his relationship as being one about being the father of the child, prior dating relationship, all those types of things, correct?
Yes.
Okay. He, in this phone call, admits to breaking her car window, right?
Yes. he did.
Towards the end of the call, he then says, I didn't know who it was. And he admits to swinging at and breaking her window. You remember that? Like you said, I didn't know who it was. It was just that homegirl.
objection, Your Honor. I would ask that the court's hearing of the recordings.
So noted, but I guess I'm trying to figure out where we're going with this.
Yeah. So you're aware then, and I'll try and see if without playing the other video, the circumstances in the next jail call from November 7th changed drastically, don't they?
Your Honor, I would object to this.
Drastically in what way?
I object to this line of questioning. At this point, I believe it's cumulative to introduce the next tape, if that's what it means.
It can't be cumulative if I'm saying that there's a change. That it's different.
Okay, but hold on, because we're going to get to. I have a doctor who's an expert in forensic psychology who says she has done her interview with the defendant in this case, that the defendant has said things and that her conclusion is the basis for what he's saying is something that is delusional.
Right.
And then uses that on the factors. Okay, fine. As you're going through all of these questions, and you may feel a different way, I may feel a different way, Ms. Gaines may feel a different way. On what basis is that you're asking the court to make a determination, and I don't see that I'm going to have anything else on the other side?
Ultimately, Your Honor, you're the one that makes the determination of whether the defendant's competent or not. That's.
Oh, I understand what my obligation. Thank you for pointing out what I do. But what I'm saying is, you're asking. Let me just do it this way. Just hypothetically speaking, the doctor here who's telling me that this individual is making statements that, based upon her professional opinion, they are based upon some type of delusional thought.
Mm-hmm.
You go through your questioning, he then says other things. You may feel that they are different. She has heard the tapes, so wouldn't I first, or the recordings, Wouldn't the first thing be as to whether or not hearing those recordings would change her assessment of the defendant's status of competency?
That would be on approach to doing it, yeah.
Okay, but what am I doing right now? I'm hearing your view of that.
And I'm proposing the theory that he's just making up.
On what, though? But hold on. I have an expert telling me one thing. I have your feeling about something else, and I'm supposed to make my decision. And if I make my decision, let's say I just agree with your feeling.
Yep.
But I've got expert testimony on the one hand. I'm just supposed to absolutely discount that? I mean, normally, Mr. Emmons, what I'll have is I'll have somebody who's an expert who has made their conclusion. You come in, you may challenge their conclusion. The doctor may have to admit certain facts that maybe, and I'm not saying this is the case, that maybe she didn't see, didn't take into consideration, didn't do whatever. Then what I get is I get another expert that says, here is this conclusion, but if you knew this and knew this and knew this, would there then be another conclusion that one would come to? Then I at least have things to choose from.
That's correct, Your Honor. And that's an option that we can take. My rationale here is to ask her, based on what I'm going to refer to as the refining of the lie, as evidenced by the jail call, if that does, in fact, change her opinion. And she might agree with me, she might disagree with me, that is it possible that he's malingering? And not only does that give us something to chew upon.
Okay,
today,
but hold it. Then let's get to it. I don't know that I need to know what your feelings are for you to ask this doctor about what her opinion of what statements he may be making are.
The evidence that I'm seeking to introduce, though, I think is important, not just for today's proceeding, but even if you do find the defendant is incompetent but restorable, down the road, this is something that the court should continue to consider.
Your Honor, that so if that is the purpose of this hearing, then I completely object, because the issue today should only be competency, and this should not be, in particular, given that I don't think that there's any discussion of a mental, or there's anyone who disputes a mental illness history of my client. To then, this hearing should not be something that can be used and then used again, and actually the ultimate trier of fact if it gets to that point. Because the issue today that you're talking about is very narrowly competency. And if that is the purpose of the entering of the recordings, not whether or not that has altered the doctor's opinion, but as simply a way to lay a foundation for a future hearing that they imagine, because you can be rendered competent.
Can I just say, in the 20 some odd years I've been doing this, I get competing experts. That's what I get. So sometimes when the forensic center says that somebody's competent and the defense doesn't believe that's the case, I have an IME, I have somebody else that's saying, I think this doctor got it wrong. Okay. So again, let's assume, just for the sake of argument, that the good doctor here got something wrong in what she did. At the end of all of this today, how do I get there? What am I going to have on the other side of her opinion that's going to lead me to dispute what she says?
Well, if that's the case, then, Your Honor, you do have the authority to order an IME. That's something that
It was not requested.
I believe the statute says that the defense, the prosecution, or the court can order the IME.
I didn't ask for this hearing. You asked for the hearing.
I recognize that, Your Honor.
Then why aren't you asking for the IME?
Well,
I mean, I don't think you can put it on the court to do that. I am satisfied as I read the report that this doctor has written. I'm satisfied with the report. You're the one that's not satisfied with it.
Right.
So why didn't you ask for the IME?
Speaking with the doctor, I believe that whatever conclusion she's going to come to, if she's going to come to, that it might form a basis that I might need to consider an IME in the future.
I guess I don't understand why we don't have it now.
I mean,
You're challenging her. You're challenging her finding that she has made.
right.
I'm saying to you, fine. I don't mind sitting for the hearing, listening to what the doctor says. What points you challenge it, but at some point I have to make a finding.
And fair enough. I'm entitled to make the argument that I'm making, and if you come to the
No, you're not entitled to waste everybody's time. If you're going to have an IME for me to weigh the differences between what this doctor says and what another doctor says based upon other evidence, then fine. But what I'm just seeing here, Mr. Emmons, quite frankly, is a waste of time because I don't see another expert. I don't know how I get there. And if you're talking about something further down the road, Ms. Gaines, rightfully so, is objecting because she's entitled to the finding at this point. I mean, court's going to stay in recess.
All right.
All right, we're back on the record in the case of the People versus Williams. Counsel is present. Before this matter even proceeds any further, there's going to have to be a decision made. If the people are challenging this, there has to be something on the other side.
fair enough, Your Honor. I mean, I understand. I take the court's point. I'd at least ask the court to allow me to ask her if listening to Joe calls has changed her opinion.
Doctor, if you could please take the stand. Doctor, I remind you that you're still under oath. All right, go ahead, Mr. Evans.
So, Doctor, again, I supplied you with some other stuff ahead of this hearing, correct? Is it possible that his legal strategy is based on a system of lies and not to
Objection, Your Honor. Relevance.
Well,
Is it possible? Yes, I don't think that's consistent with his overall clinical picture, but it's possible.
okay.
I will overrule the objection. I'll allow the answer.
Okay. All right. Nothing else, Your Honor.
Ms. Gaines, do you have anything on this witness at this time?
No.
All right. Doctor, thank you. You may step down. All right. So what the court will do is, and I don't know where the parties want to proceed with this. I mean, if the testimony that I have right now and the court has to make a finding, I'll make the finding. But if there's going to be something else coming forth or either party wish to request that I have something else come forth, I'll entertain that. I'm not, and I just want to make it very clear on the record, I am not, from the court's perspective, ordering an IME. So the court is not going to order one. I will make my finding, or if either party wishes the opportunity to get an IME, I will grant that. But
Can we just briefly approach?
you may. Yeah. Record should reflect we have a bench conference in this case. There has to be a determination, I think, based on what the court is saying, if there's going to be expert testimony on the other side. Determination has to be made as to whether or not there's going to be an additional independent medical examination of this defendant. certainly that decision can't be made tonight. So I'm going to adjourn this comp hearing to January 19th, 2023. I'm going to set this at 9 a.m. Doctor, your presence is not required at the adjourned date. If it's required at a later date, then Ms. Gaines will likely be in touch with you then. We may require your presence, so I don't want you to think that you have to come back on that day. All right. So I'll adjourn it to that time, and then we'll proceed from there. Bond will continue in this case.
Thank you.
There's nothing else. Thank you.
This closing sequence brings the hearing to a standstill, but not a resolution. Judge Simpson recognizes that the prosecution has challenged the expert's findings, yet has provided no competing expert testimony. Without a second opinion, the judge cannot simply discard the forensic conclusion. At the same time, he acknowledges the defense's objections and the complicated nature of Williams' mental state. By adjourning the hearing and allowing time for an independent medical examination, IME, the judge preserves fairness. Competency is too serious to rush. The stakes, due process, constitutional protection, and the integrity of the criminal system require thorough evaluation. Across this hearing, the expert consistently described Williams as presenting with delusional, paranoid, and inflexible beliefs that shape his legal reasoning. These impairments, she testified, prevent him from rationally assisting counsel despite his ability to recite legal definitions and describe courtroom roles. Judge Simpson must now weigh whether those impairments truly undermine Williams' functional ability to participate. As the case moves forward, the IME, or lack of one, will determine the next chapter. If found incompetent, Williams will undergo treatment aimed at restoring legal understanding. If found competent, the case proceeds toward trial, where his shifting narratives and cognitive distortions may become pivotal. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.